Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Today I'm talking about the cyber siege on law firms. Massive E&O risk there, class action claims coming after them. And of course, the courts have gotten angry. We're going to take a look at what they're doing that could really impact a law firm in a very negative way. Now, before we do that, this video is brought to you by Ciardi and Aston Lawyers for the Situation. You've heard me talk about them before, as well as a new sponsor, X-Clause, coming to you here very shortly. So go ahead and check those guys out. Sign up for their wait list if you are an MSP. Now, here are some older headlines just to illustrate the point. This is 2024. Why law firm data breaches are skyrocketing. Bloomberg Law, 2024. 2024 on pace to set law firm data breach record. Later in the year, law firm settles data breach lawsuit, a warning for legal professionals. And then, of course, Law 360. This is more recently, as of 2025. Despite years of warning and heavy cybersecurity spending, law firms remain prime targets for cyber criminals. Hey, why would that be? Because law firms have a ton of highly confidential information that, imagine it's not PHI, PII, or PCI. Well, there's probably still a bunch of very sensitive information that, obviously it's under seal. You have attorney-client privilege for a reason. You don't want that information being leaked out into the world. And I would remind everybody listening to this, yes, we have seen instances where not only was it the breached firm that got hit with the ransom, but then the bad guys either say, hey, if you don't pay us this money, we're just going to release all these files online. Good luck with that. And or then bad guys get those and they start trying to individually ransom clients into not releasing that information. Okay, so not a boat that you want to be traveling in. That would be an absolute nightmare if that were to occur. I would also add, if you go back into my book, Damage Control, you will see where a law firm actually got hit by anonymous. So, of course, we're in this kind of hyper politicized, polarized world right now where this one particular law firm, they were defending alleged war crimes against service members. And with that, anonymous came after them, breached their entire system, and that law firm no longer exists because they just published everything online. All right? You don't want to be that firm. I'm sure as an attorney, you've put your blood, sweat, and tears, millions of billable hours into that firm. You don't just want to see your life's work evaporate because some bad guy got in a way that's really very easy to defend against. All right? Now, going back to ABA formal opinions, if you go into my book, you've got 477R, 483, 498. Literally no one ever cared. I couldn't find a single instance where a state bar association went against a law firm with some type of ethics complaint dealing with these particular formal opinions. Now, I would also add, because no attorney I've ever spoken to even know this book, they don't even know this book exists. All right, but this is the ABA Cybersecurity Handbook. It is about like 700 some odd pages. Really a phenomenal book. I have read it, but I would add, just for context here, if you go on Amazon, it's got one review with no comment on it. It's probably, I think it was $120. And as I said before, no attorney I've met has ever even read this book, much less knows that it exists. Okay, so I think that's kind of setting the stage for where law firms currently are. I think this is a huge blind spot for law firms where, hey, you have all this information, you have all these potential requirements, all these risks bearing down on you, but you're not quite taking cybersecurity seriously enough. And hopefully this presentation will help you see the errors of your ways. Now, court systems obviously have been hit. Why? Because we need court systems to operate as a society. If the courts go down, everything kind of goes to hell. But also, what do they have? A ton of very sensitive information that's under seal that could be beneficial in a myriad of ways to the bad guys. All right. So the courts are starting to take this seriously. Now, just through my research, you'll see at least 8 states over the last 18 months. This was as of last year. I've seen Pennsylvania, Florida, Georgia, Missouri, Mississippi, Colorado, Ohio, Kansas, Alaska, etc., all have court system which have been hit. So the court systems obviously have decided to fight back. This is just in New Jersey to illustrate the point. It is not the only one. I will expound upon this a little bit later. But just to show you how seriously they're taking this. New Jersey, new formalized rules under Rule 132-2A. If they detect a potential breach before the user, they're going to start blocking emails and disable all associated accounts, which means your e-file access might just get shut down, and that would be disaster. Breach users must notify the judiciary, who will investigate, quarantine, etc. And then they were so kind as to put this in there. If an entire office or firm may have been compromised, now notice may, and I would put money on they are going to err on the side of caution here and just shut everybody down until there's some type of attribution, something more has been done. And you can demonstrate that as a law firm, because why would the court system just take your word for it or put their entire system at risk? So they say if an entire office or firm may have been compromised, the judiciary may suspend all accounts at that office or firm. That would be an absolute nightmare. Now, we're also seeing Southern District of Florida, California Superior Courts, the New York Unified Court System, Texas, Florida, other states as well. That was just through some brief research on my end here at about 1 o'clock in the morning. So I'm sure that, hey, if you're a law firm watching this, I would highly encourage you to go to all the states in which you were admitted, start taking a look at what their particular rules are. I would be, if I was a betting man, I would say, hey, if they haven't done it yet, it's probably in the works because that's just the way that the world is moving forward. Courts just can't take this risk. Now, what would happen if your access got revoked? Well, now we're looking at the potential for massive E&O exposure. So now your professional liability policy could be at risk. So just briefly, dismissal of the case could result in the case being dismissed. That could be a problem. Default judgment, if you fail to meet a certain deadline, could result in a default judgment in favor of the opposing party. Sanctions, being monetary fines or disciplinary actions. Moving on here, damage to a client's case can harm a client's case, obviously. Request for relief or extension. Success of this depends on the reason for the delay and the court's discretion. So generally, that's probably not a position that you want to be in if you're fighting a case. And of course, malpractice liability. You could be liable for potential legal malpractice here. And that is not going to be particularly fun. All right. This is just notwithstanding the idea that, hey, you could have massive reputational harm to your law firm. If your firm gets hit, your clients might start thinking, hey, I have all this sensitive information. I have all of these NDAs, which are now exposed. What's my potential liability here? If I don't do something after my law firm got breached, if they get breached again, is the board going to come after me? Am I going to get fired as the CEO? Yeah, that could be a problem for you. So you just don't want to be in this position. But it doesn't quite end there. Don't forget this wonderful chart from Dwayne Morris. You will see these are data privacy class action filings by year, and you see this humongous spike over the last couple of years. And I would bet once we get all the 2025 numbers in and Dwayne Morris recompiles this data, you're going to see another increase here for this year over what we saw in 2024. If you go back to 2019, when I first started looking at data breach class actions, effectively it just didn't exist. It wasn't a thing. Typically, you had to be like $1 billion company and lose at least, I believe it was 200,000 records. Now they're going after everybody, and I'll show you that in a sec. But how are they doing this? How is the plaintiff's bar going after SMBs as well as law firms that have been breached? They're using state laws as well as showing the company wasn't adhering to their pertinent data security regulations or reasonable cybersecurity precautions. Now, if you're a lawyer here, obviously you are familiar with the term reasonable and what that means. Shout out to Judge Learned Hand. I am a fan. Probably the coolest name ever. But don't forget, Arkansas, California, Connecticut, Delaware, etc. You'll see the list of states there. their breach notification laws also include a reasonable cybersecurity requirement. So it's not just as simple as, oh, well, here's the list. I can adhere to this and I'm going to be good. Nothing bad is going to happen. No, it depends, right? It's all about the reasonable person standard. You have to start applying that to your firm at a minimum. So let's say you have a bunch of healthcare information, right? Do you now fall under PHI? Are you processing credit cards? Is that PCI? Do you have a ton of financial account information? Is that GLBA? These are all things that you as an attorney, I will leave that up to you, but I would tell you, you probably don't want the plaintiff's bar using those particular rules against you. Now, claims against law firms post-breach, yes, they are occurring. Obviously, the large firm cases, those are an easy search, but it's really kind of an easy search for every industry at this point. So I wanted to bring in some normal size firms because, yes, smaller firms get hit too. 4-partner law firm in Massachusetts, I'm keeping this vague for obvious reasons. Class action, you had $150,000 reward. 19-person law firm up in New England, class action claim, $1 million. Now, that is also a problem because now you have to think as a law firm, okay, one, do you have cyber insurance? And two, how much cyber insurance do you have? Because now you have to worry about, all right, you had this problem. Maybe the courts are very angry with you or they are displeased. They might shut off your access. Now you have a huge potential E&O exposure. You had to pay for the cyber event to begin with, plus all of this potential reputational harm. But then on top of that, now you might have to deal with some type of class action. So obviously, defense expenses plus damages awarded to the plaintiff, that could start adding up quickly. So maybe that $1 million cyber policy that you're leaning on and you're not really investing in cybersecurity, that may not be the best idea. Imagine if regulatory bodies come after you, because we're seeing that as well. Class action claims comes in through the discovery process, all this information comes out, and then the regulatory bodies say, hey, thank you for that wonderful work, plaintiff's bar. We're going to start using that for our own purposes and launch a regulatory investigation against this organization just to prove a point because it's going to be cheaper that way. So please don't be in that situation. And then, of course, slightly larger 100-partner law firm, class action currently ongoing there as well. So, moral of the story, if you're a law firm out there, please talk to your MSP, talk to your IT folks. You don't have to be an expert on cybersecurity, right? I'm not going to quote, section and verse of some obscure formal opinion. But what I am going to say is, obviously you are a subject matter expert in your area of the law. People come to you for your expertise. So please go to your MSP, go to your IT folks. Start with a simple question of, hey, what's the biggest bang for the buck? What can I do to reasonably increase my cybersecurity posture here? Then maybe go out to a data privacy professional and say, hey, what particular laws do you think I fall under? What do I need to do to start checking those boxes? Work with your MSP or your IT folks to make that happen. All right, with that, that is about 13 minutes of me talking. Hopefully the point came across here. If you like this video, please like, share, comment, and subscribe. Right above me here, I believe YouTube will recommend another video for you. And over there, if you click on my face, you can subscribe to my channel. All right, guys, with that, stay safe.